Hi everyone, welcome back to Law Wednesdays. My name is Jharna Sahijwani and आज हम एक बहुत ही important issue के बारे में बात करने जा रहे हैं जिसके बारे में आपने बहुत कुछ सुना होगा, पढ़ा होगा. Recently, our Chief Justice of India, Justice D.Y. Chandrachud, has also spoken a lot about this issue, which is nothing other than right to privacy. So, in today's session, we will understand what is privacy, what are the concerns around privacy, specifically in India, how it was developed as a fundamental right, and what is the current status of right to privacy and the various regulations around it. So, moving on to the understanding of what is privacy. So, if you see, privacy basically is nothing but to be left alone. तो अगर मैं अपने घर में या मैं अपने ऑफिस में कुछ कर रही हूँ, doesn't mean that anybody and everybody can enter in my space and do as they please. That is completely not allowed. However, this is a very narrow understanding of privacy. When we look into today's understanding of privacy, given how technology has changed the world, how technology has developed, बहुत important है हमारे लिए ये समझना कि privacy क्या है, because all of us today are putting up our pictures, our various different data on different social media apps or websites such as Instagram, Facebook, and so on and so forth. So we need to understand that what is this understanding of privacy. So like I said, privacy is nothing but to be left alone. But this is, like I said, a very, very broad understanding. So we will look into what is the legal understanding of privacy. So as you can see here, it means free from any unwarranted interference. So what this means is that if I am undertaking a particular task, if I am doing something in my personal life where I am not giving access to anybody, nobody has the right to interfere, इंक्लूडिंग द गवर्नमेंट. ये बहुत इंपॉर्टेंट है हमारे लिए समझना कि गवर्नमेंट, क्योंकि वो हमारा काफ़ी डेटा कलेक्ट करते हैं, जैसे कि हमारे बर्थ रिकॉर्ड्स. इफ़ यू सी, अ बर्थ सर्टिफिकेट इज समथिंग विच इज़ क्रिएटेड बाय द गवर्नमेंट, स्टोर्ड इन द डेटा इन देयर रिपोजिटरी फॉर एजेस टिल यू डाई, even after that. So for us to understand what is right to privacy, this understanding is very important, that we have to be free from any form of intrusion or interference in our home, correspondence or reputation. So it's not just restricted कि मेरे घर में कोई नहीं घुस सकता, but also मेरे reputation, मेरे बारे में कोई कुछ personal बात बना रहा है या कुछ कर रहा है, that is also something which is a violation of right to privacy. Whether it's true or not, that is a secondary thing. The first thing is that nobody has the right to interfere. So like I said, this includes not just my personal data but my sensitive data as well. So when I say personal data, it would include things like my name, my phone number, my address. But sensitive personal data would include things like fingerprints, biometrics of any kinds. So all of this is also very important. So this is the understanding of privacy from a very generalistic point of view as well as a legal point of view. Now we will understand how has the concept of right to privacy changed or originated. So first and foremost, the understanding of right to privacy was given by the United Nations Declaration of Human Rights, which is the UDHR. Article 12 clearly lays down that anybody who is an individual or a company or an organization has to be away from any form of interference or any form of intrusion, be it, like I said, their family, correspondence, home, reputation of any kind. So if we say the origination of right to privacy happened with the UDHR, उसके बाद हम बात करेंगे इंडिया में right to privacy कैसे आया. So इंडिया में सबसे पहले right to privacy का डिस्कशन हुआ एक बहुत ही लैंडमार्क केस में, which is MP Sharma versus Satish Chandra in the year 1954. Yes, long ago in 1954 was where right to privacy was first discussed. However, it was not recognized as a fundamental right. What the Supreme Court said is that any form of intrusion in terms of surveillance or any form of visit, search, seizure during an investigation process either by the police or any authority is not correct, or it is violative of some form of rights. But they did not talk about right to privacy as a fundamental right. Neither was it recognized even as a constitutional right. Now we'll move on to another landmark judgment, which is Kharak Singh versus State of UP. ये एक बहुत important judgment था जहाँ वापस right to privacy के बारे में बात हुई, जहाँ कुछ ये बोला गया कि हाँ एक इंडिविजुअल स्पेशली एन अक्यूज जहाँ पे पुलिस रेगुलरली कीप्स विजिटिंग फॉर एनी फॉर्म ऑफ इन्वेस्टिगेशन on an everyday basis is a clear violation of his confidentiality of his personal space, which is there under Article 21. Again, please note that right to privacy in this case was also not recognized as a fundamental right. It was merely said that within the purview of Article 21, we can say that an individual has the right to personal space even if it's an accused. Now we move on to another case, which is Govind versus State of MP, which was in 1975. Here an interesting change that was there was that yes, it was recognized that there is something known as right to confidentiality under Article 21 within the purview of right to life. But again, there was no clear-cut demarcation or no clear-cut guideline which said that right to privacy is a fundamental right. Moving on to 1994, where came a Rajgopal versus State of Tamil Nadu case. Here, the Supreme Court spoke about a prisoner's right to go ahead and write his autobiography who was given a death sentence. Now, this was very important because the government and the other authorities didn't want this book to be published, but the Supreme Court here said that every individual, irrespective of whether he or she is a prisoner or has been awarded a death penalty or not, they have the right to go ahead and publish. They have freedom of speech and expression, which is laid down under Article 19 and obviously under 21. So all of this, yes, is not absolute in nature, but definitely exists. Another landmark case was in 1998, which was Mr. X versus Hospital Z. Here, this case was pertaining to an HIV positive person. So the doctor in this case revealed the information of an individual to his would-be wife and family, which eventually led to his marriage not being successful. They couldn't go ahead and get married. So this person, Mr. X, went ahead and challenged this, saying that the doctor or the hospital in this particular case has actually violated his right to privacy. Here, the Supreme Court was in support of the petitioner and clearly said that this is in violation of right to privacy. Again, there was no recognition of it as a fundamental right, but it was definitely recognized as a constitutional right. Now that we have discussed various cases which have not recognized right to privacy as a fundamental right, तो ये right to privacy का इतना बड़ा issue कहाँ से बना, कहाँ से इसको fundamental right बनाया गया और कहाँ से इतना सारा आज discussion हो रहा है. So इस सब का root है Justice K.S. Puttaswamy versus Union of India case, which was decided in the year 2017. This is one of the most landmark cases till today that we have seen, which has recognized right to privacy as a fundamental right. This has changed the face of our understanding of right to life, because इससे पहले for years different jurisdictions have recognized right to privacy as a very important fundamental right, but India did not do so. It is in this case that actually the Supreme Court of India went ahead and declared it as a fundamental right. So now we'll look into the timeline of this case and we'll understand what actually happened in this case. So first, before we understand this case, I want you to understand that there is something today that all of us are using, which is nothing other than an Aadhaar card. Now, Aadhaar card is nothing but a 12-digit unique number that every individual in this country has been given. तो आपके मेरे सबके पास आज आधार कार्ड होगा ही, क्योंकि गवर्नमेंट ने ये एक पॉइंट पे मैंडेटरी कराया था. सो ऑल ऑफ दिस स्टार्टेड विद आधार कार्ड. सो आधार कार्ड और द बर्थ ऑफ आधार हैपेंड समवेयर इन द ईयर 2006-2007. The government relied on various schemes, linked various schemes to it in order to ensure that every individual has an Aadhaar card. Now, not just this, the government went ahead and created a specific entity called the UIDAI for the creation, recognition, storage and maintaining records of Aadhaar. So जब अपन आधार की बात करते हैं, आपको याद होगा जब आप अपना आधार कार्ड बनवाने गए थे, आपने बहुत सारा डेटा दिया था, like your name, your birth date, your address, and एंड मोस्ट इम्पॉर्टेंटली आपका फेस स्कैन हुआ था, आपका फिंगरप्रिंट स्कैन हुआ था, आपके आईलिड्स का स्कैनिंग हुआ था. सो ऑल ऑफ दिस was collected as a part of data under the Aadhaar card. Now, given all of this data that was collected in the year 2012, Justice K.S. Puttaswamy, who's a retired judge of the Supreme Court, went ahead and filed a writ petition challenging the same, saying that this is violative of right to privacy under Article 21. Now, the main reason or the main argument that the petitioner in this case had was the fact that collection of such biometric data, which amounts to sensitive personal data and personal data, is not correct and also not being taken care properly. So if you understand, आज अगर मेरा data collect हो रहा है, I would want it to be protected, to be secured in the best possible manner today. But हम में से किसी को ये actually पता ही नहीं था कि ये data collect होगी, कैसे store हो रहा है, कहाँ यूज़ हो रहा है, क्या किसी थर्ड पार्टी के साथ शेयर हो रहा है, नहीं हो रहा है. सो ऑल ऑफ दिस वाज समथिंग दैट वी वर ऑल अनअवेयर ऑफ, बट जस्टिस के.एस. Puttaswamy was the one who challenged this, saying that this is violative of right to privacy. So the Supreme Court of India went ahead and considered the petition. Then there were various questions that were addressed. First and foremost was that there was an interim order that was passed by the Supreme Court in 2013, which said that Aadhaar is not to be made mandatory. So first and foremost, please understand, as of today also, Aadhaar is not mandatory as a proof of an individual. Yes, you can have an Aadhaar card, you can show it as a proof, as an identity proof, but it is not mandatory. But when in 2006 and 2009, when UIDAI came up and they came up with the whole idea of Aadhaar, they made it mandatory. The government supported this, the government made it mandatory, but the Supreme Court went ahead and declared that it is not mandatory for any individual. उसके बाद बहुत सारे interim orders और आए जिसमें Supreme Court ने clearly बोला कि जो भी benefit schemes हैं, जो भी relating to our mobile, our telephone, our electricity, all of this doesn't necessarily have to be linked to Aadhaar, because the government actually went ahead and said that all your KYC documents, all your information pertaining to banks or your phone, SIM cards, everything has to be linked to Aadhaar. In fact, for any individual to claim benefit from any welfare scheme also, you need to have an Aadhaar card. So the government went ahead and said that all of this is not right in nature, because to deprive anybody from not having an Aadhaar card to not avail the benefits of a welfare scheme is wrong. So ऐसा बहुत सारा डिस्कशन हुआ. Finally, in the year 2016, Supreme Court went ahead and said to the central government that please do not make it mandatory, especially when it comes to welfare schemes. Eventually, like the central government went ahead and, like I said, went ahead and linked the telephone numbers as well, or mobile numbers as well, to Aadhaar. But also, this was challenged in the eventual petitions, and finally in the year 2017, the Supreme Court laid down that Aadhaar is not mandatory. It can be used as a valid identity proof, but it is not mandatory for every individual to have. Certain schemes or certain places is where Aadhaar can be linked. So they said that Aadhaar is constitutional, Aadhaar is valid in nature, but the fact that it has to be mandatory in nature is not absolutely important. Another landmark thing which I have been talking about, which the Supreme Court has said in this case, is that right to privacy is a fundamental right. Here, Justice D.Y. Chandrachud, back then, who was a part of this bench, also went ahead and said a lot of other things with respect to how, when we are talking about a democratic government, right to privacy becomes important, and schemes such as Aadhaar may end up violating the same. This was a dissenting opinion, yet a very crucial part, because of which currently we are looking at a structure of a data protection bill. Yes, it is only and only after this judgment that there was a Justice B.N. Sri Krishna committee that was created, and today we are looking into a brief structure of Indian data protection bill. तो क्या है ये इंडियन डेटा प्रोटेक्शन बिल, क्यों आया, ये सब हुआ बिकॉज राइट टू प्राइवेसी वाज रिकॉग्नाइज्ड एज अ फंडामेंटल राइट। अब जब हम राइट टू प्राइवेसी की बात करते हैं सो टेक्नोलॉजी बिकम्स वेरी इंपॉर्टेंट, लाइक आई सेड इन द बिगनिंग। इफ वी आर टॉकिंग अबाउट टेक्नोलॉजी, ऑल योर टेक्नोलॉजीज टुडे कलेक्ट डेटा इन सम वे और द अदर, either it is through your fingerprints or your face scan to unlock your phones, or your phone numbers, where banks also use the same for OTPs, or basically like your food apps use your addresses. So this is where all of your data is being collected, is being stored by private entities and also government entities. So the question that arose, or the whole concern that is arising, is कि ये जो सारा डेटा कलेक्ट किया जा रहा है क्या वो सेफ है, क्या वो सिक्योर है, क्या वो किया जा सकता है, अगर वो किया जा सकता है तो कैसे वो प्रोसेस कर सकते हैं, क्या वो थर्ड पार्टी के साथ शेयर कर सकते हैं क्या नहीं. These are all questions that we don't have an answer to, but a data protection bill or a data protection act will be an answer to that. So we'll just quickly look into the timeline of the Indian Data Protection Bill. Like I said, in 2017, Supreme Court declared right to privacy as a fundamental right. Eventually, a committee of experts was set up, which was headed by Justice B.N. Sri Krishna, who is again a retired judge of the Supreme Court, who created the Personal Data Protection Bill in 2018, which was circulated amongst various stakeholders and various suggestions were asked. ये बहुत time तक चला, different kinds of drafts of the bill were shared in 2019, 2020. However, there were serious concerns with the bill, and today, as of today, when we are talking about the Data Protection Bill, very recently in the year November 2022, the Data Protection Bill in the current format that it was actually withdrawn. Why it was withdrawn is something we'll look into eventually, but please understand currently this data protection that we are talking about, the rules surrounding it are only and only in the nature of a bill. There is no act currently, it is only being proposed for a proper creation of a framework in order to protect the data. अब हम बात करेंगे कि ये डेटा प्रोटेक्शन बिल एक्चुअली क्या है. सो दिस डेटा प्रोटेक्शन बिल इज डिराइव्ड फ्रॉम द जनरल डेटा प्रोटेक्शन रेगुलेशन ऑफ द यूरोपियन यूनियन, also famously known as the GDPR. Now this GDPR was passed in the year 2018 by the European Union and has acted as a base of understanding data protection rules, regulations, framework all across the world. So now this particular Indian data protection bill also relies on this GDPR, and then there are certain terms that they have laid down, like the data fiduciary, data processor, data principal. So all of this basically entails that जिसका भी data collect किया जा रहा है, that individual is known as the data principal. अब जैसे अगर I am an individual and my data pertaining to, say, during the Aadhaar, all the biometric information that was collected, that is being collected by the UIDAI, which is an organization or an authority set up by the central government. So this UIDAI would act as the data fiduciary, because they are the ones who actually go ahead and process, store, collect the data. Now, at times, this UIDAI may share this data for further processing to any other third party. So that third party would be known as the data processor. So all of these terms are laid down under the PDPB. Also, like I spoke about personal data, sensitive personal data, critical personal data, all of this is there in the current form of the PDPB, which is, like I said, only in the nature of a bill. There are certain important principles also which this PDPB talks about, which has again been derived from the GDPR. The first important principle is lawfulness, fairness, and transparency. So any data fiduciary or a data processor which is collecting the data has to lay down clear-cut guidelines and inform the data principal as to how this data is going to be collected, used, stored, how long it is going to be stored, all of this information. Secondly is the purpose limitation. So any data that is being collected has to be for a particular purpose, and the data principal has the right to know what this purpose is. So if today the UIDAI is collecting my data, it is for the purpose of creation of Aadhaar card, and I should know that it is only and only being used for that particular purpose and nothing else. Third principle is data minimization. So which means that if there is some data which is eventually being removed from the information that is collected, I should be told of the same, being the data principle whose data has been collected. The fourth principle is accuracy. So whatever data that is being collected has to be accurate in nature. So if my date of birth is a particular date which reflects my age, it should be absolutely accurate in nature. There shouldn't be any form of discrepancy. Another principle is storage limitation. So if a data is being collected, me as the data principal, I have the right to know that for how long this data will be stored, where it will be stored, whether it will be shared with a third party for storage purpose or not. I should be aware of this. Another principle is integrity and confidentiality. So obviously the whole issue around this is that this particular data has to be maintained in the most confidential manner, be it sensitive personal data like my biometric information or even my personal data like my name. And the last principle is accountability. So every data fiduciary or a data processor has to be made responsible and accountable for all the data that they're collecting, storing, processing, analyzing, or whatever that they are doing with it. But in case of any issue with the data, they should be able to be held accountable and responsible. Now moving on, there are certain important rules under the PDPP which they propose. The first and the foremost is that PDPP is not restricted just to India. So if there is a foreign company, like we talk about Facebook or Meta as we know them. So now Meta as a social media platform collects data of individuals all across the country. So a lot of us are on various social media apps like Instagram, like WhatsApp, like Facebook. Now Meta, being an organization outside India, even though it is not situated in India, it can be held liable under the PDPP because it is collecting the data of Indians or people who are residing in a particular territory. So अगर आगे जाके मेटा जो हमारा डेटा है वो किसी और कंपनी के साथ शेयर करते हैं for the process of analyzing or any other processing, then in that case the PDPP can actually go ahead and hold them accountable and lay down some form of fine. So another important thing is the kind of fine or the kind of penalty that has been laid down. आज तक इंडिया में जितनी भी legislations रहे हैं इस तरह की penalty कभी हमने नहीं देखी, इतनी बड़ी penalty which is 15 crore rupees. So if there is a violation of my personal data or sensitive data or critical personal data, if there is any form of leakage or any form of issue where none of these principles are followed, I or any other company is actually entitled to a sum of 15 crore rupees or 4% of annual global turnover, whichever is larger. It also lays down various criminal offenses which are important. However, like I said, the PDPP is still not being passed. The major concern around it is the fact that there are certain rights like the right of data portability कि मेरा data actually कहाँ जा रहा है, किसके पास जा रहा है. अगर मुझे एक data एक platform से दूसरे platform पे switch करना है, मुझे इसकी permission नहीं है, which is not laid down under the PDPP. और right to be forgotten कि अगर मेरा जो भी data कहीं पे भी store हुआ है, मुझे उसको erase करना है या मुझे नहीं चाहिए कि वो उस platform पे रहे for whatever personal reasons, I do not have that right as per the current version of the PDPP. Another concern with the PDPP is that the age of consent for digital data in under the same is only 18. However, there are various concerns around it because as we are looking into the changing world, even individuals or children who are lesser than 18 are actually on various social media platforms, are using technology for various educational purposes. So they should have the right to do so, and that is why the suggested limit is 16. So ये सारे concerns हैं, but obviously there is a lot of hope around this because ऐसा legislation India ने कभी नहीं देखा है और ये बहुत important है given how much we rely on technology today. So I hope that this video was helpful. I hope कि आपको समझ आया कि राइट टू प्राइवेसी क्या है. ये एक बहुत ही इंपॉर्टेंट टॉपिक है फ्रॉम योर क्लैट स्टडी पर्सपेक्टिव. सो प्लीज़ please read more on this topic because this is a very contemporary issue which can be asked in your paper. And for more such interesting videos on law contemporary topics, please subscribe to our channel. Thank you and bye bye.